Good evening and welcome to Transition Talks Tuesdays. My name's Tim Markle. I'm director of the Wisconsin Youth Health Transition Initiative. Transition Talks Tuesdays is one of our projects to try to help families and providers and our friends understand more about the complicated area of transitioning to adulthood, especially when you are or have a child, young adult, with special health care needs or disabilities. The fall 2024 Transition Talks Tuesdays is being presented in partnership with the Children's Resource Center South out of the Wasteman Center, as well as the Autism Society affiliates of Wisconsin. Autism Society of Greater Wisconsin, Autism Society of Southeastern Wisconsin, and Autism Society of South Central Wisconsin. And we're very grateful for their support. I am excited tonight that we have George Zaske joining us to talk about supported decision-making and guardianship. Supported decision-making is an alternative to guardianship. Not every individual with an intellectual disability needs guardianship and the subsequent loss of civil rights. Supported decision-making is an approach in which an individual is assisted with their decision-making, which will enhance their skills, develop more independence, and allow them to take charge of their life. George, for many times over last years, thank you so very much for being with us tonight.
Sure, not a problem. Um, I was part of the group that worked to get the supported decision-making law drafted in Wisconsin, so I've been involved with this topic for some time, and I think it's a valuable option for families. A little bit about myself. I am the father of a adult with a cognitive disability. I'm also a practicing attorney. I practice in Minnesota and Wisconsin. I've done guardianships in Minnesota and Wisconsin. There are some differences between the states, and I'll try to point out some of that because I think Minnesota does something that I'd like to see Wisconsin do, and Wisconsin does some things that Minnesota doesn't do yet. I'm also a longstanding board member for a service provider here in Hudson, Wisconsin. I'm up close to the border, across the river from the Twin Cities. As a board member, I get to see the service side of providing for people with disabilities, supports. We have a day service program, and we run into sometimes challenges working with a guardian of a adult that's in our program. We make a habit of making sure we have the guardianship order because tends to be a view that if a parent is there with their child, sometimes, and certainly in the past, less so now, I hope, that the parent has guardianship. And that's not necessarily the case. And also, they may not have full guardianship, so they can't make decisions in certain areas. So we like to see the guardianship order. And I'm also an advocate at the state level for disability and policy issues. There's a lot here. I can talk a long time on these topics. I'm trying to be concise and give you the information that hopefully is helpful to you. So let's get started. Um, Standard lawyer disclaimer. I'm here to educate, provoke thoughtful family discussion. Guardianship is not something that, you wake up one morning and say, oh, let's do guardianship. I think it's warrants discussion, looking at your options, talking with others, getting educated. And that's what I'm hoping to do with some of this information today. And I'm not giving legal advice that you can rely on. I don't know enough of your facts to be able to do that. So I did talk with Tim a little bit earlier to get a sense of the audience, and it sounds like it's mostly parents. I sometimes will do presentations on supported decision making for educators, for care professionals, legal professionals. So it runs the gamut. And I tend to do a public service announcement because I don't think not enough people use this option for providing for finances for their loved one. The ABLE account Wisconsin doesn't have its own ABLE account yet. We finally got legislation through last year so that Wisconsin will have its own ABLE account, but Wisconsin has authorized the use of ABLE account for people with disabilities. You just have to use a different state and participate in that ABLE account. And I can tell you this provides for more flexibility and more options for your loved one if they work a little bit, or if, I'm an attorney, I do trusts. Sometimes people don't have enough money that really warrants drafting a trust. So I usually tell folks when they first come into my office in the area of estate planning and supplemental needs trusts that create an ABLE account. Educate yourself on it. This ablenationalresource.org is a really good resource. Lots of frequently asked questions, and they give you a tool to compare different ABLE accounts for their features. So I highly recommend it. We don't have enough of it being utilized. And so I usually do one of these regardless of the presentation I'm giving. It's my public service announcement. All right. What is supported decision making? It's really something that all of us do. When I bought my first car, I got support making that decision. It was from my dad. When I bought my house, it was my parents that helped me. I'd never bought a house before. So we all use supported decision making. It's not a really unusual concept that requires deep education. We do it every week more than likely, where we're talking to people. Maybe a friend is, an expert in pick a topic. You're doing a house remodel. You're trying to find information about good air conditioner. You just go down the list of everyday decisions. Where's a good bank to go to? Who has good customer service? So we're using family members, professionals to help with our decision making, and that's really the crux or the heart of supported decision making. It's not it's not a lot of, as I said, education where you have to really become steeped in it. And a little bit about the current state and why supported decision making, I think, has come about and is utilized more, is we have a changing world. And when people with disabilities got out of high school, 20, 15 years ago, some of these things didn't exist that are on this list. There wasn't, there weren't ABLE accounts. Uh, there wasn't Project Search. Think college. People with disabilities, intellectual disabilities can go to college. There wasn't CMS's final rule for getting folks integrated into the community. So we're always changing and growing as a society and getting our chance to have new options. And for a long time, it was just guardianship, and that's what people did. You were told that at around 17 and a half, your kid's going to leave high school, they're going to transition to the adult services world. And so it was get SSI, get your long-term care, get guardianship, look for a group home. Some of that still happens, I think less, but there's also more change coming with technology and what people can use to be able to provide security, to provide some oversight. Attorneys now are being trained so that they understand about supported decision making. The courts are understanding about supported decision making. We have judges now that are asking if supported decision making has been tried before guardianship is ordered for an individual. And I'm also a big proponent of, if I'm not against guardianship. There are options and situations where they're very appropriate, but if you look carefully at the statute and you look carefully at the petition for a guardianship, you can have a limited guardianship where you don't take all the decision making from your loved one. You don't take away their right to vote. I actually had a couple of years ago, took a case on where I helped restore a young man's right to vote, which was really awesome. And social studies was his, and history were his favorite subjects in school. So he knew more about the political landscape than many of his peers, and he should never really have lost his right to vote. But um, that's what happened to him. We were able to get it restored. So you can look at that, and we'll go a little bit through the petition where you can see all the different powers that are taken away from the individual and giving them to someone else. Supported decision making is supporting the individual to make a decision. A guardianship is you're removing the decision-making authority and putting that into somebody else. Occasionally, I'm going to tap on the chat box here to see if we've got anything. Oh, Tim's put some out
No,
there,
I
so I'll
am
check it
I
on
am
occasion.
totally spamming everybody with links to what you mentioned, George.
Okay.
I do not see any questions yet.
All right.
But
Okay.
please do feel free to put questions in the chat and we'll take them as we go along.
Yep. So, okay. So why am I not? I'm not. For some reason, my slides are up there now. It's at advancing. Sorry about that. One of the things that has come about in more recent times is brain development and what they can do with scans in terms of MRIs, fMRIs, CAT scans. And what has been determined is that the human brain is not fully developed by 18 or 19, 17 when guardianship gets put on. In fact, the brain doesn't fully develop until around the age 25. And that's true for all of us, whether we have a cognitive disability or not. Um, there are instances in my past that I'm not proud of, but my parents did not agree with my decision making when I made some decisions at age 21 and 22. And I think that's true for a lot of people. And as you get, as that brain matures, the areas that are changing in the brain, the physical structure of the brain, is increased connectivity and in the area of executive functions. And those are really important when it comes to making decisions, when it comes to making plans. And so the prefrontal cortex is where all this development is happening. And the areas that get developed are things like attention, because when you're younger, maybe you don't have such great attention. Complex planning, multiple steps, decision making, impulse control, logical thinking, organized thinking. Your personality develops a little bit more. And your understanding of risk and risk management. So all of these areas are developing. And what research found that when somebody is put under guardianship and all the decision-making authority is taken away from them, these areas do not get very well developed. They atrophy because the person doesn't get a chance to use these skills. Now, you can take a supported decision-making approach while somebody is under guardianship, but we all run into situations when we get paperwork, it's just faster to fill out the form myself, sign it and get it in. I mean, it's human nature. And when we give our loved ones an opportunity to make decisions, to help with their planning, to help them build steps to getting to a decision of making an expensive purchase, maybe a car, or, when my son was younger, gaming systems, and there were lots of them, and I had to learn about those to be able to support him. But the more we use these different functions of the brain, of the prefrontal cortex, the stronger those links and connections become, and the better we get at it. And guardianship tended to short circuit that. And it promotes healthy brain development in areas of of decision making. And what decision making helps is you give them cognitive challenges, you continue education. Education doesn't just stop at age 18 or 19 when you leave high school. There are opportunities like we have, like you saw on the list, Project Search. There's Think College. We have a program up here in at Northwoods College called Hospitality Foundations, where it's a certified program. It's accredited, where people learn skills that can help them get jobs in the service industry, like hotels and restaurants. So you want to have an environment that allows for enrichment and then also socialization, figuring out how to interact with other people, understanding social cues, and those are all things that can happen after high school. So if you hold off on the guardianship, and one of the things I often point out to people is you can still put on a guardianship for someone. But if they're living in your house and you have a good relationship with them, and maybe they're going another year to high school to the transition program, is it really necessary to put on a guardianship? There used to be that, oh, they'll sign a contract and buy a car, and in this day and age, that's really hard to do because they're going to do a credit check, right? To sign a car, to buy a car, and to get a loan. And if your loved one doesn't have a lot of credit history, their credit score is not going to be so great. So I think are there some risks? Absolutely. I hear from folks that, oh, they'll just get up and move out. Well, a guardianship really doesn't give you the power to call up the sheriff's department and say, my son is over at a friend's house and I don't like that friend. I want you to pick him up and bring him home, and I'm the guardian. That doesn't work. That you can't use a guardianship in that way. So there are some protections, I think, that are really misunderstood about what a guardianship can really do. So everything for a guardianship, and I talk about guardianship because to me, this is the most powerful tool and powerful court order that's out there. It's been said that a prisoner in the corrections system has more rights than someone under a full guardianship, which is actually true. But it begins with a court action. You can start as early as 17 and a half. It's easy enough. The forms are online so that you can do them yourselves. And I think this is where some families get into a dilemma because they do it themselves. They don't hire an attorney. They don't do a lot. They get in a situation where they feel like they have to have a guardianship to be able to support their loved one. The problem with having a guardianship and you get it through, they're really hard to change. They're really hard to undo. So this is something that I think requires a lot of thought. And so this is an example of the guardianship petition. It's a PDF form that you can download off the court's website. You can fill in this information by yourself. Attorneys use it. This is a standard form, so all the court personnel, the judges have all seen this form. And it's very easy to fill out. You identify, guardian of the person. In Wisconsin, we also have something called the guardian of the estate, which other states call a conservatorship. That's control of the money. And that might be something that's appropriate if you're concerned, if the person can make decisions about their health care, who they live with, their friends, but they're really not very good with money. It might be appropriate to have a guardianship of the estate. There are other options out there that that can be considered when you're looking at this. And then you can see down at the bottom there, you can go for a permanent guardianship. This form's used for a permanent guardianship, guardianship of the person, guardianship of the estate, standby guardian, temporary guardian. So there's a lot packed into this form. And if you look at the bottom, maybe you can't see from the bottom, but this is page 2 of 7. So this petition is really not that big. And I actually filled one out at a presentation I gave. Oh, sorry. I don't know what happened there. A presentation that I gave, and I asked somebody, I gave them a stopwatch and asked them to time me how long it took me to fill out. Now I have a little more experience filling these out, but basically on a overhead projector, I filled it out in about 5 minutes. So I use that as an example to say that I took 5 minutes to fill out a form that in the end could take away virtually all of a person's civil rights on 7 pages. So here you go with the guardianship of the person, number 15. You can rights to be removed in full, right to execute a will, right to serve in a jury, or right to vote. Now, maybe they shouldn't execute a will, maybe they shouldn't serve on a jury, but I also am involved in Disability Vote Coalition. And I don't know about you, but there are a lot of people who are pretty um, straightforward in their voting. They'll vote based on a single issue, pro-environment, not whether which a party or not a party. There are, Second Amendment, not. So the you just need to understand who is up for election and what they stand for, and you should be able to vote. It's not, there are different levels of competency. That's the other thing here too. This whole process um, is designed to have a determination and a person declared incompetent. But there are different levels of competency. There's a different level of competency to understand a complex medical procedure or the side effects of a drug or the ins and outs of an employment contract or a loan agreement versus voting. So you need to think about that as you're going through this process. But as you can see, the other things that can be removed, the right to marriage. And then we go through here, and there are other rights that can be removed, applying for a driver's license, consenting to sterilization. There are other things that can be as limited capacity um, to participate in medical trials, where they live. Um, so a number of these things. And here's an example too. If you look at this, if we go down and you go F, the power to give informed consent to release confidential records other than court treatment, patient. You can choose one or two, and every one of these has a choice one or two. One is the individual retains limited capacity and the power to. So in there, you can write some limits of what they have the right to decide about, as opposed to number two, which says the individual lacks evaluative capacity in full, the guardian of the person to exercise full power. One of the examples I give is financial. Give them the limited right to make purchases. Pick a dollar amount, $400, $500. Maybe so that they feel like they have some autonomy and some control about their lives. And so that's why going through each one of these powers and giving some thought about, okay, what is it that we're looking to remove and what is it that we can keep with the individual? And then basically you sign it and you file it with the court with the filing fee, and that kicks off the process. So,
George, quick
yeah,
question for you.
yep.
So families could go through that process and they have those options. In your experience in dealing with guardianship, does the judge, the court generally say, "Yep, sounds good," and sign off on it? Or is there a chance that when you go to the court, the judge is going to say, "Nope, I'm going to choose this and I'm going to choose this"? And does that happen?
Generally, well, see, the court is very deferential to parents. I mean, it's just, you know, human nature, common sense. They've been taking care of this loved one. No one knows them better than the parents. And that's usually when this is put on. I mean, you can put guardianship on your parents as they age and have dementia or Alzheimer's. I think we're going to see a lot more guardianships. And I know people in the profession, in the system, there's concern that guardianship is just going to start getting bigger and bigger and bigger as people have to find ways to take care of their and make decisions for their elderly parents who are living longer, but that longer living, has memory loss, dementia, Alzheimer's. I mean, so guardianship is used across the lifespan, really. Somebody's in their 40s, they are in a car accident, traumatic brain injury, they might be put under guardianship. But what I'm talking about and what we're seeing and what we're looking at as the advocates is on the front end of a child's life as they transition from, 17 and a half into adulthood, from the school system into the adult system. And excuse me, there's not a lot of research around guardianships. I actually got consulted by somebody just last week about a guardianship petition that they received. And I could tell from the case number that it was only, and it's a small rural county, it was only the 11th guardianship this year for that county. So depending on your counties, so then a judge might not see very many of these versus other counties. They might have a whole probate division, and that's generally where guardianships are, is in the probate division of the court system. There's a criminal court, there's family court, there's civil court, there's probate court. But you could have a small judge and they deal with all of those things in some of these smaller rural counties. But when the study was done, they found that hearings last approximately 15 minutes. So I'd like to pause there and say somebody just lost all of their civil rights, given decision making to somebody else, an order that's going to last for 30, 40 years. Somebody else is going to get it because if the parent's the guardian, odds are the child will outlive them with modern medicine. And so somebody else will be the guardian. That may be a family member. You may not have a deep bench, so it isn't a family member, and then it's a professional guardian. Some of those guardians, professional guardians, their case files are pretty extensive. But I have actually been in hearings where I've sat and watched decisions being made in 15 minutes. It has kind of an industrial complex feel to it. So again, is guardianship the best option? Because I think there's some assumptions made that, oh, if I can't do it, somebody will step in, and that's really fraught. That's not necessarily true. And I've talked to families and it's like, well, who's your standby guardian? And it's like, well, my sister will be. And it's like, and how old are you? Well, I'm 75. And how old's your sister? Oh, she's 70. Well, how much time are you really getting if you were to pass away for your sister to be the successor guardian? And guardians can resign. There's no obligation to, if you're appointed a guardian, that you have to stay a guardian. And the other thing about with supported decision making and the idea of letting your child, your adult child, learn more, make decisions, is they can be better prepared for transitions, because other studies have shown that only 25 to 50% of families make concrete plans for the future. And that is, okay, who's the successor guardian? Is their trust money set up? Are they going to move into a location, more independent of the parents? Because the second bullet is most adults with developmental disabilities will live with their parents well into middle age. And the transition generally happens at the death of the parent or a health crisis. The parents being wheeled out on a gurney, going to the ambulance, and their adult child is sitting on the sofa, and it's like, okay, who steps in? And if you don't have a plan, who steps in as adult protection? The EMTs, if if it's Saturday night, and I've heard anecdotal stories about this over the years, and I kind of combine them to make the point is, mom's got to go to the hospital, EMTs show up, she's agitated because their adult child is sitting there, no one else is in the house. It's February, it's Saturday night. If there is nobody, if you don't have a plan, the EMTs are going to call the sheriff's department, and then the sheriff's department is going to call adult protection. That's the mechanism. There's a mechanism so your child just doesn't go splat on the concrete, but that transition is not a real good one. People will do their jobs, they'll be kind, but what happens then too is you can have individuals when that circumstance arises that they're not understanding. So then they start having challenges. And we've all, I'm sure, heard the word start having behaviors. And then you can get a reputation for being uncooperative or being aggressive or maybe being physical. And part of it is just their inability to communicate the fear and anxiety that they have when they see their parent leaving and there isn't somebody else or it hasn't been thought about this. So guardianship, this whole transition is an iterative process and you can build on it, and it doesn't all have to be done at once. You have to be thoughtful and make progress, but you need to think about, okay, what's going to happen? What's our plan? Who's the successor? Do they understand? Because as a parent, we have so many roles that we do, and we do them because we love our child and we will continue to do them. But the idea that you can find another individual, and maybe you can, I'm skeptical, even a sibling, who will be the rep payee, who will be the guardian of the person, who will be the guardian of the estate, who will be the trustee on a trust, who will take the person to the doctor's appointments, who will provide transportation, who will follow up on their living situation. I mean, I'm going to run here. The screen's going to disappear with my fingers. We do all those things, and I find it unlikely you will find another individual, not a parent, who will take on all those roles. And the other thing I say is it really fair? Because if you have a sibling, they're going to have a life too. They're going to want to have, a career. They may be married, have children. They may have health issues. They may not. They may have problems handling money. Maybe they're not the best person to be in charge of the ABLE account or the trust. So we need to think about how we're going to disperse some of this workload and have multiple eyes on our loved ones. And that requires some thought and planning. And that goes back to when at 17 and a half, you start thinking about what's the future going to be like. And many, earlier on in, it's changed, but it was basically standard practice. If you had a child with an intellectual disability, if you used an attorney, they might draw up a will, they might to fund a trust, and they'll get guardianship. It was just sort of like, standard practice. Nobody thought of alternatives. And as I've said before, it does implicate the person's constitutional rights. And this is what it is. It's the court-ordered loss of all your personal freedoms. This is the guardianship statute for the state of Wisconsin. A friend of mine, he's Mitch Hagopian. He's an attorney for Disability Rights Wisconsin. He retired maybe 2 years ago. He's the one that really, he turned me on to the language in the statute that says, even if somebody is under guardianship, bullet B, the guardian needs to make a diligent effort to identify and honor the individual's preferences with regard to their choice of place of living, personal liberty, mobility, who they associate with, personal privacy, sexual I mean, all of these things, the guardian should be touching base and working with the person under guardianship to see what it is that they want. Because if there's a conflict there, you place them in a living situation that is convenient, or you're desperate and you had to put them there and they start acting out, it's not going to work. So the statute recognizes that even if you have guardianship, even if you're under guardianship, the guardian should take a diligent effort. Now, I'm skeptical that if somebody's under guardianship and they go to a corporate guardian and they have a file of 50 cases, I mean, just think about it practically. How frequently can you get to know somebody and meet with them if you have a caseload of 40 or 50 cases? Now, you can make sure that they're safe, their bills get paid. I mean, it gets managed, but whether they really understand and are able to put in place services that, really promote the quality of life for that individual with a disability, um, I think it's legitimately, I legitimately question that. So, and there are alternatives, and some of these alternatives even existed before supported decision making.
So we do have somebody that would like to ask a question. Is it
Sure,
okay to take questions at this time?
sure.
Good. Go ahead, Maison. Feel free to unmute and ask your question. Or you can put it in the chat and I'll ask it. Either way.
Can you guys hear me?
Yes, sir.
Yeah, thank you. Thank you for this talk. This is important. So
Sure.
I guess I have my questions are related to what you were saying. So we don't have to do, so it's regarding our daughter with disability. My wife and I are both part of this meeting. We
Yep.
don't have to do it at 17 and a half, do we? Or can we wait?
No, you can wait.
That's what okay.
Yeah,
So you
yeah,
don't,
absolutely. I
yeah.
think it's a good idea to wait.
Right, right,
Because 17 and a half, I mean, they're still finishing high school, but
right,
but the law allows it. And when you're concerned about the future, I mean, we use supported decision making,
right,
but and I'd been been in part of the development of the law, studied this, and even myself, I started filling out the supported decision make. Excuse me, the guardianship petition, because the anxiety, the fear is real. It's just on a personal level. It's for me to talk, you know rationally and in a professional capacity, is one thing, but to actually be there and and have to think about, oh boy, what about the future? Yeah, the fear is very real. The anxiety is very real, and went partway down that path myself, knowing all
right,
that I know. And, my son's, he's 27 now. We just moved him out of the house in July. He's living on his own. He's got supports. He has a job. I mean, I think of, would he be there if we'd have put a guardianship on him at 17 and a half? I think very unlikely. So yeah, if
right,
you can wait, and the other thing is, if you're, worst case scenario, there are emergency temporary guardianships. Your child decides, oh, I'm going to get in a car and go to wherever. I mean, we know our children pretty well. We can start to see the signs. And you'll hear, occasionally there'll be this horror story of, somebody just they moved out and they're living with a bad crowd. Well, if you got guardianship and they're that resistive to staying, can you really control them with a guardianship? Maybe you
right,
can maybe put some safety measures in, but I think more of it is talking with them, understanding, and then giving them opportunities to take risks and fail, not catastrophically.
right,
But, my son made some purchases, with his debit card that I would not have made, but it didn't break the bank. He felt
right,
the pain of it because then he couldn't do some other things. So if you can delay it, because then it gives you more information to then go and say, oh, we don't need to take this right away from her.
right.
She can still have it because we've seen enough instances of. So yeah, delaying is a reasonable thing. One of the things I like about Minnesota, and they just changed their law a couple years ago, is they have something called a time limited guardianship. So that anyone under the age of 30 who's put under guardianship, that guardianship only lasts for 72 months. Then you have to go back in, which I really like because it recognizes the fact that the brain isn't fully developed
Right.
and that maybe the guardianship can be changed when they're, when they're 21, and maybe it can be changed when they're 25 because we've learned more things. Their brain is developed. There's more opportunity. So there isn't this petition that goes through and is granted and put a guardianship order on somebody at 17 and a half, and it lasts through their 20s, 30s, 40s, 50s, 60s. That's
Right.
big. That's heavy duty stuff.
Let me ask you a follow-up question.
Sure.
What about when, again, we go see physicians? Let's say, she's a child. She will just turn 17. But let's say she's 19, but we don't have, can we still make decisions for her?
Nope.
For medical decisions?
Nope. And I'm not, I won't, as a lawyer, I won't tell you what you want to hear. I'll tell you what the facts are, what the statute is, what's real.
Right.
But that's not to say that there aren't options for you. Your child can sign a medical release. They can sign a power of attorney. And then you can be involved in the decision making with them. My son was in a car accident. It was a minor car accident, but we wanted to get him checked out, fortunately, for that situation. But they took him into the examination room by himself. And after about 5 or 10 minutes, they opened the door and they had asked my son, did he want me there to help him? And he did. But we had signed medical releases. We had talked to our doctor and talked about that we weren't going to go with guardianship, that he needed support making his medical decisions. So part of it is also educating the systems, because if we don't press the systems, then, they're not going to change either. And they're just going to want the expedited way. And I'll put to you as well. You have an elderly parent. They go to see the doctor. They're hard of hearing. We're going to be going into more of those doctor's appointments. Now, we can't make that medical decision for them, but they need support. And that's why I'm saying if this is where you're moving into, start preparing, have those conversations, practice. Then it's not so foreign. And are there risks? Yes, but I think they're manageable. And also there's risks with everything else as well. So we don't get away with that. So
do my wife and I become co-guardians, or is that how it goes? I guess if we decide to do guardianship.
I mean, you can do co-guardians.
So equal rights.
To me,
but both
well, the thing is it and or? Because again,
okay, got it.
Who steps in if you pass away, for example? Then do you have a successor co-guardian? And is it your brother that your wife doesn't like? We have, as attorneys, we try to figure out down the road what potential risks there are, or tensions, or complexities. We can only realistically go so far, but that's what you need to think about. Is it a co-guardian that it's that both guardians have to agree with the decision? Is it an or? I do family law and I do divorces, and some of the most challenging work that I have to do is in custody and med management, when one parent believes that medication's appropriate, particularly for ADHD, Ritalin, that kind of thing, and one parent doesn't. And you actually have to I've been in cases where I have had to get a court order ordering a parent to give medication when they had parenting time. Right. So, these can be really fundamental, deep value issues that, it's at a superficial level. Oh, that's not a problem. It's like, but when when it really counts, you're really under pressure, these things come to the fore.
No, I think this is important. So we actually did do estate planning and with our attorney, and we have a thing called estate planning for special needs. So We already have the document, so at
Okay.
least for the estate planning. Now, in the estate planning, so obviously it's a revocable trust that we have,
Okay. Yep.
and my wife and I are both now, holders. But when one of us passes away, the other one becomes, and then we appointed our son as the if both of us pass away. Can we do the same thing with guardianship? We're training him to take care
Yep.
of his sister. So
Yep.
the same thing can happen with the guardianship.
Yep.
Okay.
And again, it's likely that the court doesn't have to approve your choice for successor guardian. It's not an automatic.
Okay.
But it's at the court's discretion. But oftentimes, if it's a family member, they know it's going to happen. But say, for example, and I don't mean to cast dispersions on your son, but your son starts having substance abuse problems.
Yes.
And, some other family member says, hey, wait a minute, he can't have access to that money because it'll just go for his habit. And I know they had that, but his, parents have been gone 5 years. He had a back injury, he got onto opiate. I mean, you can spin out the hypothetical, right? But I don't want people to think that, oh, if I put my son or daughter in there, the sibling, that they'll do it. And the other thing is they can resign.
Yes, no, I just for sure. No, I think that's important. So we're good. Thank you.
All right. Yep.
Thank you, Mazen. So we do have another question, George, and I also know that we're about 10 minutes till the end, and I know we want to get into support decision making. But do you have anything, or I could also have her contact you outside of this, but the question is, what do you do if you're questioning guardianship at 18, so the person's 18, so you've already lost the legal abilities for medical issues in SSI and other entities, especially for someone who has severe cognitive and communicative disabilities?
You're gonna have to run that by me again. I missed it.
I was kind of afraid of that.
Yeah.
So what do you do unless Candy, would you like to unmute and just explain? You don't have to turn your camera on. If you just could give a brief explanation, that would probably be more helpful. I'm watching for unmute, but okay.
Sorry, I was just trying to unmute it, and I'm like, whatever.
I understand.
So like, my daughter is 17 now and is going to be 17 and a half March, in March. And I'm going through this process of learning everything. And I know at 18, I have no autonomy over her medical or any of the other entities, but she has severe cognitive disabilities. Obviously, I don't want to take her right of voting away and some other of the other things. But also, she has no ability to make decisions on her own right now. And it's scary for me to have like the guardianship for her entire life too. So it's like I do need the autonomy to be able to do that thing. I mean, that Minnesota thing sounds really good to me because like that's what I would need, like for her. To go and make and say, oh well, she's able to do more and more things, so let's reevaluate. But when you go into guardianship, you lost the ability to reevaluate. It's pretty much saying as far as I'm understanding. So I want to know what we do in that situation. Like,
I mean, that's the problem that we have with our system. It's an overly broad. It's a heavy hammer and everything is a nail kind of the metaphor. If there's severe cognitive disability, I'm not saying a guardianship isn't appropriate. But if you're educating yourself, you're becoming thoughtful. We also have to work with what we're given, right? Our system's set up this way. You won't be able to make a medical decision for her at 18. So you may want to go with a guardianship, but when you go through the guardianship petition, there might be some things that, we don't have to take the full power. We can take a limited power. Now, guardianships can be modified in the future. It's a pretty big hurdle to overcome because if you think about it, the person has been declared incompetent. Judicially, after an evidentiary hearing, broadcast to the world, if you lose the right to vote, you're put on a list at the Elections Commission saying you are incompetent. So if you want to change that, then you have to look at, okay, how do we demonstrate that they are more competent? that they've grown in this area. So there are ways that you could go back at it, but I won't sugarcoat it. It's a more daunting task. But if safety and decision making and medical are important, because of the system that we have, because we're in Wisconsin and not Minnesota, you're going to have to work within the framework that we have. But I think, as I said, you can still have guardianship, but give them opportunities to make decisions, to take some risks, have some failures. And the other thing that studies have shown is the more decision making, the more people are engaged in their own planning and deciding, making choices for themselves, they are actually better at protecting themselves. Studies have shown that they're less risk because they have a more refined sense of self-autonomy, body autonomy, choice autonomy, and so they're less likely to be exploited. So, it might be that you need to do guardianship. But that's partly because of the situation that we have with our laws. So.
Okay, thank you very much.
Yep. So some of the alternatives, I'll go through these pretty quick because I know we're running out of time. Generally happens to me. Do a petition for appointment of a conservator or a guardian of the estate, because that way you control the money. And if they don't have the money, there's not a lot people can do. You can't rent an apartment to move out if you don't have access to resources. So that's something to consider. You can do durable power of attorney for finances and property. There's a form online from the state. You can fill it out. Don't need an attorney to do that. Many of us, I think, are going to be doing this for our elderly parents to help them with their finances later. So you could use, and I have one of these for my son, durable power of attorney, so I can help him with his banking. You can do power of attorney for healthcare. Now, this one's not the same as power of attorney for financial. This is more in the realm of if the person is unconscious, in a coma, that sort of thing, you can make decisions for them. It's not, you can't use this for going in for a regular doctor visit. It's not what it's designed for. So I like to clarify that for folks. You can do custom releases. If you're going to work with the hospital to get HIPAA information or the bank, they have releases that you'll need to fill out, but you can also, as an attorney, I was able, and this, maybe not everybody can do this, but I was able to draft some customized releases for some situations that we ran into to provide some liability protection for the people that I'm working with. You can do a limited guardianship just because, that you can take all the right away for a particular area of that person's life. You don't have to. You can do limited guardianship, not a full guardianship. And then again, supported decision making. There is a form, but it's not just the form. It's a thought process. It's an approach. It's trial and error. And so it's a series of relationships. You can have multiple supported decision making agreements, one for somebody to help with your loved ones, excuse me, finances. It can terminate. So there's a lot of flexibility. Somebody can be a supported decision maker, the supporter, we call them, for healthcare. Going to the dentist, deciding whether, a root canal or, veneers are appropriate. They could keep the right to make the decision, but they have supporters to help them. And you can have multiple agreements, different people, in different areas where they might have some expertise. It's still developing. As we move forward and get more experience with it, we're learning some things. So it's an area that's still evolving, which I don't think is a bad thing. Here's the values of supported decision making: autonomy, self-direction, trust, respect. I stole this from Kate Schilling. She's an attorney that I know from a presentation she did a number of years ago. That's what supported decision making really helps do. The other concepts to consider, and these can be, we could have whole 30-minute conversations on presumed competence, which when somebody turns 18, they're presumed competent. The guardianships is an attempt to remove that presumption and have them declared incompetent. Dignity of risk. You know, I might decide to, you know, ride a bicycle without a helmet. You might think that's dumb. It probably is dumb, but I can make that choice. There are other things where, you know, we can't take away a person's dignity by making their life so risk-free. And again, that's the whole idea of guardianship as a substitute decision maker, a supported decision making is you're supporting the person making the decision. These are all the states that have supported decision making laws. So I think we're close to half. I think I could probably update this list. And what still bugs me is that Texas had a supported decision-making law before Wisconsin did, which I found rather unusual. And the areas that are promoting supported decision-making is in the areas of attorney training, self-determination training, the statute in the legislative, the Wisconsin statute, it's chapter 52. If people care about that, you can bring that up and search for it. And then WINGS, I participated in that. It's a collection of guardians, judges, lawyers, and support professionals trying to figure out how to best support people under guardianship, because WINGS has been around. There's one in Minnesota. I participated in that one as well. And this stuff can be real life. There was a case back around 2013 where a young woman, her name was Jenny Hatch. It's quite a visible case. She contested a guardianship that her mother wanted to put on her. And the attorney, Jonathan Martinez, I've met him a couple of times and taken a couple of his seminars. He took her case and they won. She fought, and the judge put a guardianship in place for a year. All the parties had to come back, and the goal of the 1 year was to move in the direction of where the guardianship could be terminated, and she would be supported through other means. And he's actually gone national with his, you know, promotion of supported decision making. So if you do a search on him, you'll see videos, and you know, you can learn more about it. But this was a case where this young woman, she lived pretty independently, and then she had an accident on her bike, and then her, you know, her mother got concerned, and so decided that it would be best to put a guardianship under her, and she did not want it, so she had to go to court with her mom. And she was fortunate that she got representation. Not everybody is so fortunate. So, and these are the resources for you. I think Tim's got that out there. I'm a little 2 minutes over. I'm going to stay if some people have other questions.
We're going to continue with a couple of questions as we started a little late. And if you have to go, feel free. I will send you the links to the resource sheet. I'll send out the links there. But I will also send you all a link to a short feedback form. I really appreciate the feedback, but I'd rather spend time going through some questions. So one question is the first question we have is somebody's interested in who in Wisconsin is like looking into changing the Wisconsin law for time limited guardianship. Is there any group that has taken up that mantle?
Yeah, I'm part of that group.
So where would people find more information? If they
we're not at that stage yet.
Okay.
We're still trying to figure out language, looking at what would be palatable to the courts, because you know it creates more administration, because you got to come back, and with the legislature that we have, it's always going to say, you know, cost. What's the cost? And so we're trying to figure out how we can get some metrics on that from cost wise. We're identifying all the different stakeholders that are involved, like the court system, the probate clerks, So these things, these kinds of changes can take years. And so there's a small group of us that are working with the Legislative Drafting Bureau to try to come up with some language. And then we have to try to find some sponsors. When I worked on the supported decision making, I'm trying to think how long that took. It took 3 or 4 years. And, fortunately, at that time, my state senator was willing to sponsor it. So that was helpful. But we have a current political climate where, if that's the first thing that generally gets looked at. And for supported decision making, we tried to get some money put in the budget to increase the number of advisors for the Guardianship Resource Center, and we were looking for like $200,000, and it got cut. So it's the environment that we're in is challenging, but we're staying at it. We've taken a hiatus because we don't know who's going to be in the legislature with the election. So generally, and people are focused on voting and supporting candidates that they want to see going forward. And so I would encourage everybody to vote. It's important. I saw some fact or number a few years ago where, there are 51 million voters that have some tie to disabilities, whether it's a parent who has a child with a disability, whether it's a person with a disability. So there's a lot of political power. And if you think 20,000 people swung an election in Wisconsin, voting can matter. And people with disabilities and people who are have loved ones with disabilities, who's in those legislative offices, who's the head of DHS,
Matters.
that makes big difference. So consider
So,
that as we come into the election season.
Another question we have is there any teeth in supported decision making to protect the 18-year-old? Can you talk a little bit about how that person has to allow that supporter in the room that is legally binding, but the 18-year-old can still make a bad decision just like any of us?
Oh yeah, that's exactly right. Realistically, part of the supported decision making law was to get to some of these bureaucratic systems, because if there's no guardianship, if the bank could exclude you from the room.
Right.
And they didn't want somebody in because they thought, oh, the person's being manipulated, and then they're going to be defrauded, and they're going to come after the bank, and the bank's going to be on the hook because all the money got drained out of the account. Well, now with a supported decision-making form, you give that to the bank, they put it in the file, they have liability protection so that a supporter can be in the room. And they may not think it's a great decision. And they also have duties that if it's very apparent that there's going to be fraud perpetrated, I mean, there's common sense that's involved there, but you could do that with your parent.
Mm-hmm.
But there's really, that was part of the reason for doing it. So we could work, get into some of these systems, the healthcare system, the education system, the financial systems, the financial institutions. And so that was part of it, because they could just, flat out say, oh, you're not the account holder. We're not letting you in the room. And so that makes it really hard. And then, the option is, oh, well, then we get a guardianship. We take all of their rights so we can get in the room. That didn't make a lot of sense, but it's not the end all be all either. I don't pretend it to be, and none of us who were involved ever thought it would be, but we are, some of this is incremental growth, learning, incremental improvement for our communities.
So, George, are you aware of after parent or guardian dies, are you aware of any groups that can help a child with support decision making if the other relatives are not able to help?
That gets into that whole notion of, someone's circle of support. It's part of it is, finding people in the community who can step in, and that's a real question. It definitely is. We have gaps, and I have concerns about that on a very personal level. I mean, our family's small, There's one sibling and they're not even in the country. So that's something that, working at on a, sort of a on the ground level, looking to, find friendships, build friendships. The small agency I'm with, we're looking at, is there things that we can do? I know there are people who do have guardianship companies, you know, do they expand and do some kind of, pay for service to do some of that? So this is, as I said, this is evolving. We're learning as we go. And there are going to be people who this doesn't work for, or there's going to be gaps. But to me, the alternative was guardianship or nothing, or guardianship was it, and that just to me doesn't work.
I am just going to put one resource that came to my mind, and that there's a wonderful group called Love Inc., Living
Yep,
Our
they're really
Vision
good out of Madison.
Inclusively, that may be able to have some help for that parent as well who asked the question. They may have some insights too.
Yeah, well, and I can editorialize and go on about this for quite a while till
Yeah,
people's
I
eyes
need to go
glaze
have
over.
dinner, George.
Yeah, but the other
I'm
thing,
hungry.
but what I want to point out is I think we're going to have to come to the realization as family members that in small groups, we're going to have to come up with solutions for our loved ones. And you see that in communities now. There's a small town north of me called Somerset, and a group of parents have gotten together and they built a housing development, 24 apartments, all connected, because they're trying to find a place for their loved one to live safe. So the idea that DHS is going to roll out something where all
Not
of our
gonna happen.
kids, are just going to fit in this program, it's like that's not going to happen.
No.
Your child turns 18, they're in the adult system. There aren't a lot of supports there. I mean, you'll see that when you get there. There are some, but I think we're going to have to come together in smaller groups and say, okay, how do we get coverage for our loved ones? I mean, as I said, my son moved out in July. His roommate is a Special Olympics teammate of his.
Wow.
And so we've gotten to know the family really well. And so now, I feel like I could I could go off on a weekend and somebody would be, but that's what we're going to have to do. And it's work. But I realistically don't see anything else. I mean, I can't imagine with all my work at the state where I would see that the legislature is going to say, oh, here's $200 million. We're going to do this. It's just not going to happen. Group homes there's hardly any of those out there. Housing is a huge issue, but it's a huge issue societally for elders, for the homeless population, affordable housing for low-income workers. And we're all in that. And so we're going to have to start coming together as, small groups of families to figure out and then learn from one another about how we can get our loved ones protected.
I think that's a fantastic final thought, George. I thank you so very much for sharing your passion and your knowledge, and I really appreciate it.
Sure.
We will get the recording out to folks as soon as I can, along with the resource sheet. But the fact that you maintained the interest of 14 people for an hour and 15 minutes is pretty impressive.
All right.
So thank
Well,
you.
I hope it was helpful.
I learn something every time I attend, so I'll just keep having you back as long as
All
you
right.
keep saying yes.
Sure.
But thank you. Have a great night, everyone. Thank you so much for hanging in there with us. Appreciate it. Have a fantastic evening.
All right. Bye.